And the jury and all counsel. Good morning, ladies and gentlemen. Thank you for your patience this morning. Did any of you see or hear anything about this matter in the media since I last asked you that question? Anything whatsoever? Has anyone attempted to speak with you about this case? I see no responses. Has juror number 5 contacted any of you since she was excused? Please raise your hand. I see no responses. Mr. Martinez, you may continue with cross-examination.
Ma'am, when we left off on Thursday, we were talking about your approach to an assessment in this kind of case. And one of the things that you told me was that with regard to 558, that was not a roadmap, but it was a guide that you used in your evaluations, correct?
Yes.
Additionally, with regard to your evaluations, sometimes you do interviews, correct?
Correct.
And those are called the clinical aspect of the evaluation, correct?
Correct.
And in addition, in this case, you did 44 hours of interviews, correct?
Yes, I did.
And additionally, you look at other materials such as written documents, correct?
Yes,
And you review those and then you make your assessment, right?
I do.
One of the things that we were talking about on Thursdays was that even though that is the process that we follow, there's no requirement, if you will, that in this process, that there actually be an interview with anybody, right?
I'm not sure.
Well, you're the one that put together this continuum, right?
Yes, but I'm not sure how you're
Yes or
applying
no,
that.
ma'am?
No, I don't understand your question,
Judge-
Mr. Martinez. I don't understand what you're asking.
With regard to 558, isn't it true that when we started your testimony in this case, we started talking about 558? Do you remember that?
I used that to define domestic violence. Yes,
Yes
I
or
did.
no?
I defined domestic violence. Yes, I did.
Ma'am, I'm just asking you whether or not this sheet of paper, you see this sheet of paper, 558?
I do indeed.
Whether or not this was used as this sheet of paper was used as part of your presentation at the very beginning of direct examination when Ms. Wilmot was questioning you, yes or no?
It was used, yes.
And when you finished your cross-examination or your direct examination on Thursday, isn't it also true that this document was used when you were talking about whether or not the defendant was abused, correct?
On Thursday?
Yes. Do you remember back to Thursday, ma'am?
I do remember Thursday.
Do you remember that Ms. Wilmot was asking you questions for most of the day?
Yes, I do.
And for a shorter portion, there was the cross-examination, right?
Yes, there was.
At the very end, do you remember that Ms. Wilmot was using this with regard to your opinion of abuse in this case? Do you remember that?
Yes, she was using it as part.
Yes, so the answer is yes, correct?
Yes, in part.
So you do use it with regard to your assessment in cases where the issue is whether or not there's any abuse, correct?
I don't really use any specific thing. I use that as a guideline, and I don't use it to apply specifically to each case. I use it as a template in describing what domestic violence looks like, Mr. Martinez, and a range of domestic violence. That's how I use it. And I use it in training.
And you used it in this case, right?
I did not use it in regard to Miss Arias, if that's what you're asking me. I'm not sure.
No, I asked you whether or not you used it in this case in the sense that you walked into this court. Do you remember taking an oath and sitting up there early on the first day of these proceedings?
Yes.
And during the early part of those proceedings, this exhibit, this continuum of aggression and abuse was used, wasn't it?
It was used as an
Yes or no?
explanation. It was used as an explanation.
Judge, would you instruct the witness to answer, please?
Ms. Laviolette, can you answer yes or no?
It doesn't feel complete, Your Honor, to answer just yes or no.
All right, Mr. Martinez.
All right then, ma'am. Isn't it true that when you first testified, Exhibit 558, and Ms. Wilmot was asking you questions, it was placed underneath this machine here, and it was broadcast for everybody to see it in the courtroom? Yes or no?
That's true.
And at the very end, isn't it true that this guide, this template, whatever it is, isn't it true that that was used during the questioning by Miss Wilmot at the end of your direct examination in this courtroom? Yes or no?
Yes, it was.
But you're saying you didn't use it what? For any purpose in this case, right? That's what you're saying now.
I'm not saying that, Mr. Martinez. I'm saying I don't use it as exclusively as a diagnostic tool at all. I use it in training and to look at interventions in particular, but it also gives a more complete, and this is why it was used here, a more complete definition of domestic violence and the range of behaviors, and also looking at aggression that happens in otherwise healthy families that don't have patterns of domestic violence.
Are you done?
Yes, I am.
Did you use it in this case? Yes or no?
Objection as to vagueness. Which aspect of the case?
Sustained.
Did you use it in this case as part of your presentation to the jury?
Yes, I did.
Did you use it in this case as part of your assessment of the defendant?
Not in particular.
Well, then why were we even talking about this Exhibit 558 if it doesn't even apply to this case then, ma'am?
It does apply to the case.
Well, let me do it this way. If you said you didn't use it with regard to your assessment of the defendant, then what do we even need to look at this if you didn't use it?
I use it to look at the range of domestic violence. So in that way, I looked at it. I'm not someone who just lumps a diagnosis. And as I was very clear about, this is a range, it's a continuum. So I use it in that way. It's a framework that I think about. It's something that I use to look at what's happening in a relationship. So in that way, yes, Mr. Martinez, I used it.
So nothing in this 558 applies in this case. Is that what you're saying?
No, you mischaracterized what I just said.
I'm asking you yes or no. Are you telling me, yes or no, that nothing in Exhibit 558 applies as part of your assessment in this case?
I think I just answered that question,
Is that
Mr.
yes or no?
Martinez. I said that there is a range of behavior, and I used that to look at this case.
So what is on this document then was used by you in this case as it applied to the defendant, correct?
To a certain degree.
So if we want to talk about the defendant's case and we want to talk about how it is that you reach your assessment, by necessity, we can refer to Exhibit 558, right?
In a limited way, sure.
So that's a yes, correct?
Objection is characterized as your answer.
Overruled.
Is that yes or no?
You can.
And in this case, you also went through a number of answers to the questions, and you talked about the first column, and you also talked to the column to the end, didn't you?
I talked about all the columns.
Yes,
Yes.
you
Yes.
talked about every one of them in this presentation when you testified, correct?
Yes, I did.
And ma'am, one of the things that we talked about that in the context of whether or not Snow White was a battered woman, right? That's how it started, right?
I think we spent a lot of time talking
Is that
about
yes or no?
That is, yes, we spent a lot of time talking
Ma'am,
about that.
did I ask you if we spent a lot of time on it?
I'm just trying to give you a more
Ma'am,
effective answer.
Judge, would you please ask the...
Ms. Laviolette, listen carefully to the question and try to answer the question you are being asked.
Okay.
Did we discuss this in connection with whether or not Snow White was a battered woman? Do you remember that?
Yes.
And with regard to that, in fact, you spoke about that back in Los Angeles in 2010. That's what your CV shows us, right?
Yes.
And in fact, that was a keynote address back in 2010, right?
Yes.
And so if you being the keynote speaker there, you discussed issues involving whether or not this applied in connection with Snow White, right?
No, I did not.
So, but you did deliver this keynote speech back in 2010, right?
It had nothing to do with this particular
All right.
continuum.
It had nothing to do with this particular aspect, but it did have to do with whether or not Snow White was a battered woman, right?
I think I said that that was a catchy title,
Right.
and I used the catchy title.
Right, but it was in connection to that catchy title, right? The present, where you were the keynote speaker, right? Ma'am, actually, that's not true, is it?
What's not true?
Isn't it true that you did not deliver the keynote speech back in 2010 involving whether or not Snow White was a battered woman?
Well, you gave me
Yes or
the...
no? Yes or no?
No, I don't know. I don't have my CV with me, so I gave several keynote addresses, and if you are trying to trick me with a year,
Judge,
you can trick me with a year.
This is the issue we discussed.
I mean,
all right.
if you will allow me to
Ms.
see...
Laviolette, hold on for a moment. Mr. Martinez, ask another question.
Ma'am, I want you to take a look at an exhibit, which is part of your CV, okay?
All right.
Please take a look at it and see if this is not page 3 of 34 of your CD. This is exhibit 596. Recognize it?
Yes,
And that is a true and accurate copy of that particular page, correct?
yes.
Right.
Well, it's, yeah, part of it's of that page.
If I may have it back.
So,
I'm going to take the admission of exhibit 596.
Yes, Judge Bede objects unless the entire CV comes in.
Approach, please.
596 is admitted.
Exhibit 596, let's take a look at it. And specifically, at the top, it does say keynote addresses, correct?
Yes, it does.
At the bottom, it talks about Los Angeles, California, ICAN conference with Snow White, a battered woman, correct?
Correct.
Now, let me show you a copy of the syllabus of that particular conference. Please take a look at it. Specifically, take a look at page 3.
Yes.
It does reference this article, Was Snow White a Battered Woman, right?
Yes.
And it was presented by ICANN, wasn't it?
Yes, it was.
And it was presented in Los Angeles, right?
Correct.
And this is the syllabus that went with it, right?
That's
Or
not
the
a,
class schedule.
that's just a schedule. There's no syllabus
Okay,
there.
this was the schedule, okay. I move for the admission of Exhibit 597.
Yes.
Ma'am, isn't it true that Exhibit 597 shows that you were not the keynote speaker, right?
I was in Las Vegas.
I'm not asking about Las Vegas, I'm asking about Los Angeles, ma'am. Isn't it true that you were not the keynote speaker?
It was considered a keynote, there were considered keynote panels, and I was
Judge,
on
would you
one of
instruct the
them.
witness to answer, please?
He is answering.
Overruled. You may continue.
I was asked to do, there were keynote breakouts, and I was a keynote breakout speaker. And it wasn't the person who was the plenary, no, but it was considered a keynote breakout.
Ma'am, the keynote speaker actually was somebody by the name of Catherine S. Connell, correct?
Yes,
And you were just part of Studio 3, where people came by to listen to you in the breakout seminars, correct?
it was considered
Yes,
a keynote breakout, Mr. Martinez. That's why it's listed in keynote.
In your exhibit number 596, does it say keynote breakout addresses?
No, it doesn't.
So this only talks about keynote addresses, right?
I guess, I put keynote breakouts, I
Yeah.
didn't,
Ma'am, with regard to keynote, you're the one that put this exhibit together, yes or no?
yes.
Your CV is something that you control what goes into it, right?
Keynote breakouts
Ma'am,
are listed
Judge,
with
she's not answering
keynotes.
again.
Overruled. Continue your response.
Keynote breakouts are listed with keynotes. Because they're listed in the program as keynote breakouts. So that's why I listed as a keynote. I'm not trying to misrepresent myself, Mr. Martinez,
Judge-
if that's what you're implying.
Then
That's
I move-
not what I'm doing.
Then I move for the admission of exhibit 597 based on the fact that she said keynote.
No.
All right, 597 is admitted.
Let's take a look at this. When looking at page number 2, well, let's do page number 1. It does talk about ICAN, correct?
Yes,
And if we take a look at it down here, it does say ICAN, correct?
correct.
Then this indicates on page 3 that from 9:30 to 11 there was a keynote speaker, right?
Right.
And the person who delivered that keynote address was somebody by the name of Catherine S. Connell, correct?
Correct.
Now, your name's not on there, correct?
Correct.
And then you said, well, I delivered the keynote speech in the plenary sections. That's what you said, right?
No, I didn't. I was the keynote in a breakout session, in a studio session, it was called.
All right. And if we then take a look at the breakout seminars, does it say keynote speaker in the breakout?
No,
It just says that you're the person that's presenting that in this studio number 3, correct?
that's the way it was. You're implying that I think that I'm lying about what I do, and I don't lie about what I do, Mr. Martinez.
Ma'am, I'm not implying. I'm indicating that you're misrepresenting what you indicated here in exhibit number 596.
I was told.
Ma'am, let me finish my question, please.
Sure.
I'm not implying anything. I'm indicating that you misrepresented the fact that you were the keynote speaker with regard to this, was Snow White a battered woman? Because 597 indicates otherwise, doesn't it? And 597 is this one. Yes or no?
The
Objection on the record.
Restate your question.
Is the portion of the CD that we're talking about, which is 596, is it accurate when it indicates that in Los Angeles, California, in 2010, you were the keynote speaker involving this, was Snow White a battered woman? Yes or no?
I was a keynote breakout, according to Deanne Tilton, who was the director of ICANN, Mr. Martinez.
I'm not asking about anybody else. I'm just asking whether or not you believe that this says that you were the keynote speaker at a breakout session.
A keynote. It doesn't say that. No, it does not say that on there.
Ma'am, and one of the things that you seemed to indicate was that you really don't need to use Exhibit 558 when you're reaching your assessment, right?
It's a frame of mind.
I understand it's a frame of mind. I'm not asking about that anymore. I'm asking about whether or not you told me previously that you really don't need to use what's in Exhibit 558 when reaching an assessment in a case such as this.
I think that you misrepresent what I say, Mr. Martinez. I think in a global term, because I have read other people's work and my work, and I think in those terms, but do I put down a piece of paper and assess that way? No, probably not, but it's up here after all these years.
Well, ma'am, what you're indicating is that you do use it, except that it's in your head. Is that what you're saying?
I use it in part.
And it's in your head. Is that what you said? That's what you just said right now, right?
Well, it's in my head and it's on a piece of paper.
And with regard to this particular piece of paper, when, or this continuum, or whatever it is, did you or did you not use it in making the assessment in this case?
Objection asked to answer.
Overruled. Did I use it at all? Did I use it because of my head? Because of what's in my head?
Did you use it? That's my question.
I used my way of thinking, which includes that.
And so if we take a look at Exhibit 558, it would reflect what's in your head, is what you're telling us, correct?
It would reflect part of what's in my head.
And nowhere in, and you didn't write a report in this case, correct?
No,
You spent 44 hours, you reviewed a number of written documents, but you didn't put anything in writing, correct?
no, I did not.
And in your approach, nowhere are you required, for example, to talk to anybody in reaching an assessment, are you? You're not restricted in that fashion, are you?
I'm not sure. Required by whom?
By your approach. Your approach does not require you to talk to anybody or conduct any interviews in making an assessment as to whether or not there was any abuse, right?
I was limited in what I could look at.
I'm not asking you if you were limited, man. I'm asking you whether or not this approach that we've been talking about, the one that you've told us in the courtroom over these days, isn't it true that that approach does not require you to talk to anybody or interview anybody before you reach your conclusion?
That's not how I work.
I'm not asking you if that's how you work. Well, you say that's not how you work, right? That's what you just said, right?
That's not how I generally work. I generally do interviews.
Well,
But-
with regard to, for example, Chaitanya Lay, do you remember that you gave us an opinion about what you thought about Chaitanya Lay and Mr. Alexander? Do you
Yes,
remember
I
saying
did.
that?
Yes,
You
I did.
didn't talk to Chaitanya Lay as part of your opinion about what was going on between her and Mr. Alexander, did you?
No, I read what they wrote.
Right. So what I'm saying is you're not required under your approach to talk to anybody before you give us an opinion, right?
Two things, not necessarily my approach, and secondly, what I am given that I am able to review that I find credible.
I'm not asking about that. You're willing to come into court like you did last Thursday in the morning and part of the afternoon and give an opinion about a relationship involving people such as Mr. Alexander and Chaitanya Lay without talking to Chaitanya Lay and without talking to Travis Alexander, correct?
I looked at far more than that, Mr. Martinez.
I'm not asking you what you looked at. I'm asking you whether or not you render an opinion in this courtroom about Chaitanya Lee and Travis Alexander's relationship without talking to either of them. That's all I'm asking.
I did not speak to either of them.
But you did give us an opinion, didn't you?
on,
Whatever you gave us an opinion. You did give us an opinion, didn't you?
I gave an opinion within a context, Mr. Martinez, and I think that's important.
Whether it's looking at context or not looking at context, what you did is you read something and then you said, this is what I believe. That's what you told us, right?
What I believed based on a context, Mr. Martinez.
Right. And that context did not involve talking to either of the parties to that conversation, right?
That's true.
And in fact, though, you were able to tell us review with regard to Chaitanya.
I don't know if they were texts or IMs. I get them mixed up, but it was written material that involved conversation between Mr. Alexander and Chaitanya Lay.
What date?
What date?
Yeah, yes.
There was a range of dates, but
Right.
if you would refresh, I've reviewed thousands of documents, so what can I say the document that you're referring to?
No, you were the one that referred to this opinion on Thursday, weren't you, ma'am?
Judge, objection made. What opinion?
Sustained.
Ma'am, you told us that Chaitanya Lay was vulnerable. Didn't you tell us that on Thursday as it involved her relationship with Mr. Alexander? Do you remember telling us that?
Yes.
With regard to that opinion, in terms of their relationship, whatever the relationship may have been between her and Mr. Alexander, when was that she was vulnerable? Give me a date.
Mr. Martinez, there were a range of IMs. And if you're asking me to be a history major, I'm not a history major, but I read thousands of documents. And if you can refresh my recollection, I would be happy to tell you the dates.
But you, as you sit here now, you can't tell us a time period when Ms. Lay was vulnerable in her relationship with Mr. Alexander, correct?
Which part that she was vulnerable?
You're the one that said that she was vulnerable after reading either IMs or text messages, right?
I did.
And so, wouldn't it be important to know the time period when this was happening?
The time period that this was happening was in 2008. Those were the IMs or text messages I read were during the period of time between 2008 and toward the very end of Mr. Alexander's life. Those IMs stopped.
So you're positive that it was an IM message that we were talking about?
I told you I don't know a text from an IM. It was a written piece of paper that I looked at.
And in that written piece of paper,
Or pieces, I should say.
how many pieces of paper did you look at to form just this particular opinion involving Chaitanya Lay?
Mr. Martinez, I look at context. I don't have to remember exactly how many pieces of paper to form an opinion. And I think,
Wouldn't it be important to know whether or not it's based on just one text message or it's based on a whole series, if you will, of documents involving these conversations? Wouldn't that be important for you to know?
it's based on more than one text message, I can
It's
tell
based
you.
on what?
It's based on more than one of, there were several sheets of paper. There were numerous sheets of paper that it was based on.
One of the things that you also testified to was that in these kinds of cases, 90% of the communication is nonverbal, correct?
I did not say that. I said that in communication, and this is when people are looking at each other and speaking to each other, that there's a saying that 90% of communication is nonverbal. This is in face-to-face communication. I don't think we have research about what it's like now when people are doing things over the internet and Gmailing and that
So
sort of thing.
you did say that 90% of all communication in the clinical world is nonverbal, correct?
I answered that.
The answer is
I said in face-to-face communication, that is the understanding. I did not talk about it in regard to written communication.
Didn't you say it's important to me because there is a saying in the, I don't know if it's all of the world, but in the clinical world, that 90% of all communication is nonverbal. That's what you said, right?
I explained how I meant that, Mr. Martinez.
Ma'am, take a look at this exhibit. It's 595. Look at the top. You can read all of it and see whether or not those words came out of your mouth earlier in the proceedings.
I don't doubt that those words.
Ma'am, please take a look at it. Please read that for me.
It's 598.
598, I'm sorry.
Well, within this context, we're talking about Mr.
Ma'am,
Alexander.
Please read it and tell me when you're done, okay?
I,
Are you done?
I've read the entire paragraph.
Yes
and
or
it's,
no? So that is a yes, correct?
I've just read that paragraph. Is that?
Just, if you want, read the paragraph or read the whole thing. And when you're done, let me know. All right, may I have it back, please?
Yes.
Isn't it true that in proceedings here in this courtroom, you said, it's important to me because there is a saying in the, I don't know if it's all over the world, but in the clinical world, that 90% of all communication is nonverbal. Did you say that?
That is out of context, Mr. Martinez.
Sir, ma'am, I'm not asking you about context. I'm asking you whether that's yes or no. Did you say it or not?
It's not a yes or no answer, Mr. Martinez. It's out of context and it's not representing what I said.
Judge, I move for the admission of Exhibit 598. I understand that I'll have to take the other part out.
Yes.
Exhibit 598 is admitted as redacted.
All right, I'm going to take a look at Exhibit 598. The question is asked, why is that important to you, Ms. Laviolette? You see that?
Yes.
And then the answer is, it's important to me because there's a saying in the, I don't know if it's all of the world, but in the clinical world, that 80% of all communication is nonverbal. Did you say that, yes or no?
Yes, I did.
And then there's a sentence that says, and that's one of the things that we're looking at is the communication apparently by Mr. Alexander, that although he says it's okay for her to date, and then it goes on, right?
Yes, and it is in the context of
No,
also
I'm just-
personal face-to-face communication between Mr. Alexander and Ms. Arias.
I know that's what you want to tell us, but in terms of Exhibit 598, it does say, I don't know of all the world, but in the clinical world, 90% of all communication is nonverbal. That's what it says, right?
Yes.
And if we are applying that to the conversation involving Shatanya Ray and to Mr. Alexander that you told us about last Thursday, that would mean that you were 90% wrong because there was you weren't able to look at the nonverbal communication, were you?
That's quite an extrapolation, Mr. Martinez.
Is that yes or no?
That's no.
And in fact, it's important to look at what the people are doing, is what you're saying, the way their bodies are when they're saying things, right?
That's true in a face-to-face. You can't do the same thing when you've got written communication. But if the written communication is consistent over time between numerous parties, it's consistent. I don't know what else to say, Mr. Martinez.
But in communications where there are people talking, for example, in text messages, you would agree that you can't see their faces, right? You don't know what their faces look like, correct?
No.
No, you can? Or no, you can't? You can or can't?
I can't see their faces, no.
Correct. And with regard to what the person may be doing at the time that they're sending this and how they're feeling, you wouldn't get the gist of that if you're just looking at the written word, correct?
You can get a lot from the written word.
What you're saying is that by just looking at a text message, ma'am, you can tell what an individual many years ago was feeling just by looking at a text message. This is what you're telling us, right?
What I'm telling you is that I'm looking in many, many text messages, many, many communications. That's what I had to go on. And when that is consistent, I feel like that is a pretty straightforward sort of situation.
Ultimately, what you're saying is that you are a human lie detector, right?
Gosh, I didn't think I was saying that, Mr. Martinez.
Well, you're telling us, for example, that just by looking at a communication with Shatanya Lee and Mr. Alexander, for example, you're saying they're telling each other the truth, right? You're assuming that they're telling each other the truth, right?
Based on many other communications. It's part of a context, Mr. Martinez. I've said that several times, and that's really what I mean, is I look at a context of behaviors. I don't look at an isolated situation. It's always about pattern when you're looking at this.
And when you say context of behaviors with regard to this as an example, Shatanya Lee and Mr. Alexander, what you're talking about is reading, right?
That I'm reading.
Yes.
Yes, I'm reading.
Right. You're not observing them any other place other than what is in the printed word, right?
Yes.
And what you're doing is perhaps in your office or wherever is you're looking at this and you're saying, I'm going to pass judgment on what is going on in this particular conversation without talking to anybody that's involved, right?
I think you're mischaracterizing me.
Well, did you talk to Shatanya Lee?
No, but excuse me, I looked at, once again, Mr. Martinez, it's context. It's not this one conversation. I think that's important for people to hear, that it's about patterns and it's about context. It's not about one conversation with one person.
The point, ma'am, is this. With regard to what you may interpret as being vulnerable, could be meant as a joke by Miss Lay, and you wouldn't know it because you're not privy to what was going on at exactly that time that it was going on and couldn't see the faces. Wouldn't you agree?
Well, she stopped communicating with him after he talked about joking about or whatever about suicide. Apparently, she took it in a certain way and stopped communicating with him and was upset by it. So yes, part of what I'm looking at is her reaction and the fact that she stopped making communication and he continued.
She stopped communicating with him via text message, correct?
Correct.
You don't know if they called each other on the telephone, do you?
No, I don't.
You don't know what it was that they were saying on the telephone, if they in fact called each other, right?
I know that he
Yes or
pressed,
no?
I know that he pressed for communication via text and she did not communicate. That's what I know.
That's what you're saying, but you don't know whether or not she relented at some point and called him. You don't know that, right?
No, I don't, Mr. Martinez.
So you're just restricted by the written word as it applies to her, right?
Yes.
And with regard to Reagan, do you remember Reagan?
Yes, I did.
And her last name is Housley, right?
Yes, it is.
How many items did you review with regard to her? Or was it just one or two?
No, it was more than one or two. One of them was 18 pages long. There were a number that were long.
And one of the things that you told us with regard to Reagan was that she was also vulnerable, right?
Yes.
And that conversation took place on May 19th of 2008, right?
I would have to see the date. I don't know the date unless you show me the communication.
In terms of benchmarking it, you read it pretty closely, didn't you?
I did. I read thousands of things. And if you'd like to show me that and recollect the date, I'd be happy to look at it.
I'm not asking you whether or not you read thousands of things. Can we agree that you read thousands of pages?
Yes.
All right, can we move on? And I'm asking you with regard to the date. Isn't it true that in this particular email or instant message, there's a reference, a time reference, isn't there?
Objection, foundation.
Approach.
Ma'am, I'm going to mark an exhibit, and it has a highlighted portion of it.
And I probably need to get my glasses.
Please, while I'm at this. Take a look at Exhibit 599 and the highlighted portion as to the date and the time. Just the highlighted portion.
All right.
If I may have it back. Does that refresh your recollection as to the conversation involving Ms. Housley and Mr. Alexander where she was vulnerable?
No, it does not. There were numerous about that same time There were numerous conversations, so without looking directly at it, I would not be able to say this particular conversation happened on the 19th of May. No, I would not.
Well, you indicated to us, at least when you talked about their relationship, was that in terms of Miss Housley, one of the things that you told us about her was that she was vulnerable, right?
She was anorexic.
You used the term vulnerable, didn't you?
Yes, I did.
And you also are now telling us what she said was that she was anorexic, right?
Objection, Judge, may we approach? Yes, may we approach?
Continue.
So you're telling us that in this message that you reviewed, one of the things that Miss Housley said was that she was anorexic, correct?
I'm not saying on the 19th that she was saying that because I don't know what's in that communication, Mr. Martinez.
With regard to Miss Housley, you just told us that she said that she was anorexic, right?
That she had been anorexic.
Right. That's what you just told us, right?
Yes,
This is part of the information that you used in telling us that she was vulnerable, right?
yes,
Additionally, as part of that, you also indicated to us that there was some issue about photographs, where Mr. Alexander was asking for photographs, right?
yes.
He wasn't asking for nudes, was he?
He was asking for close to naked, I believe.
He was asking for what?
There was something about, he was asking for a bikini shot.
Right, he wasn't asking for nudes, was he? That was my question.
With one, he was asking close to naked, and I don't remember if that was Reagan Housley or not.
So you can't, as you sit here, when you say that he was asking for photographs, you can't tell us either way whether or not they were nudes or not, right?
They were definitely bikini.
So you're saying that they were bikini shots then?
Yes,
And that's based on what you read, right?
yes,
And with regard to that conversation, one of the things that came up was that the defendant was Mr. Alexander Stalker, right?
yes.
And with regard to that conversation, the events involving the stalking were discussed, yes or no?
Yes. There were a couple of
Yes or
events.
no? Yes
There
or
were-
no? They
yes.
were discussed, weren't they?
Yes,
Previously, when you were asked by Ms. Wilmot about that, you said, I see no evidence whatsoever about stalking. Do you remember saying that?
I still don't.
I understand. So you still don't see that even though they are referenced in that message, right?
I don't see that based on Mr. Travis's behavior toward Miss Arias. Stalking is a different ballgame, and it's a pattern of behavior, and it's a pattern that usually creates fear in the person that's being stalked. And so I don't see that with Mr. Alexander as he continues to connect with Miss Arias.
Isn't it true that when you just said fear, isn't it true that Mr. Alexander was extremely fearful of the defendant based on what was said in that conversation?
I don't get that based on what I'm looking at. Once again, Mr. Martinez, you're asking me to look at something that's isolated as opposed to looking at the context of what we're talking about.
You had no problem telling us, for example, that Miss Housley was anorexic, right?
Well, she said that.
Right. So you believed her, right?
I believed her because she talked about lots of body image
Right.
issues. Yeah.
Right. But you still believed what was being said. You never actually got a photograph of her, did you?
No, I did not.
You never saw any medical records involving her, right?
No, I did not.
You're basing it just on what was said in that message, right?
I'm not sure if it's just one message, but
But
it was
definitely-
based on the communication between
Right.
Mr.
And in terms of the
Alexander.
photographs in the bikini, when you said that Mr. Alexander wanted those photographs, his wanting is based on a statement that was made in those messages, right?
Correct.
And so you're believing what Mr. Alexander is saying with regard to his carnal desire.
Based on much information, Mr. Martinez, not based on one communication with one woman.
But you are believing it, aren't you?
I
Yes.
am believing it.
Right. So you're taking what's in this instant message and you're believing, picking and choosing what to believe and what not to believe, right?
No.
Well, in this instant message, isn't it true that without telling me what is said, isn't it true that Mr. Alexander talks and uses the word stalking as it applies to the defendant?
Yes.
Isn't it true that he talks about certain aspects of that stalking behavior, right?
Yes.
In fact, in that instant message, there's even an indication from both parties that they believe the defendant is listening in or seeing what's going on, right?
No, there's an inference by Mr. Alexander toward Ms. Housley that she is listening in.
And in fact, isn't a message typed in as part of this conversation that's directed towards the defendant?
Yes.
So it's with the indication, at least, that they believe that she's listening in or monitoring that conversation,
The
right?
judge mischaracterizes her testimony.
Overruled. You may answer.
Right?
I don't believe that. I believe, do you want to know what I believe or do you want me to?
No, I'm asking about what is going on there. Whether or not you believe it or not, we'll get to in a minute. Isn't it true that there is a written communication during the time that the two are involved in this instant messaging conversation of a message directed towards the defendant? Yes or no? Without telling us what it is.
Mr. Alexander is saying that to Ms. Housley. That's correct.
But isn't Miss Housley, as a result of what Mr. Alexander said, also type something to the defendant? Doesn't she do that also?
He asks her to. Yes.
Yes or no? She does type it though, right?
He asks her to and she complies. Yes.
And he also types something there, right?
I'm not sure about that.
And as part of that same conversation that we're talking about, this is the one that you used in part to talk about the fact that he was flirtatious, right? In that conversation, right?
Once again, I would need to be refreshed if you would have me look. You're asking me about the same date, Mr. Martinez, and when you look at thousands of documents, a date is not going to stand out, and you've got that information. You've got it.
Let me mark it for you. It does have the date on top. Disregard it. Well, take a look. Take a look at it. It's Exhibit 600. And the issue is whether or not there's any indication in that instant messaging about whether or not Mr. Alexander is being flirtatious.
Do you want me to read all 18 pages?
I want you to read it so that you familiarize yourself with it to the point that you can answer my question as to whether or not Mr. Alexander and this woman were being flirtatious with each other.
Yes.
Have you reviewed it?
Yes,
May I have it back?
sure.
Are there any indications there of the flirtatious aspect of their relationship?
Yes,
So that's included in there in terms of the issue of vulnerability as well as the photographs. And you've chosen to believe those because that's what you presented to us last Thursday, right?
based on context, Mr. Martinez.
Judge,
based
it's a
on-
yes or no question.
Next question.
We understand that it's context-based, but you have chosen to believe that in this conversation, you have chosen to believe that they are being flirtatious with each other, right?
They're talking about boobs and libido
Ma'am,
and sex.
Judge,
and-
she's just not responding.
Sustained. Listen
Ma'am.
carefully to the question.
Yes,
You've chosen to believe that. You've also chosen to believe that she's anorexic, right?
she states that.
And you've also chosen to believe this thing about the photographs. Well, when you say that she states that, you've chosen to believe it, right? You told us about it just now, right?
There's quite a discussion about it in the email.
So is it yes, you did believe it?
Yes, I did believe it.
And so you've
Recovering anorexia.
And you've also chosen to believe this issue involving the photographs, right? That he asked for a photograph, correct?
Yes,
Right? You now know that, right?
I didn't see
Move
that
on,
in this.
move
Okay,
on.
okay.
And yet, when we come to the issue of the stalking, you have chosen not to believe Mr. Alexander when he says that because of the defendant's stalking behavior, he is extremely afraid of her. Chosen not to believe that.
Based on his behavior toward Miss Arias.
Sure, but you've chosen not to believe it even though he's written it down.
He's written that he is afraid and he,
Judge, you indicated that she shouldn't say what's in there, but
Can you answer the question to what is written on the page?
what is, okay. Will you restate the question,
Sure.
Mr. Martinez?
you've chosen not to believe Mr. Alexander in this conversation, which may or may not be towards the middle or the end of May. You've chosen to believe. You've chosen not to believe Mr. Alexander that he was extremely afraid of the defendant because of her stalking behavior.
That's not the only reason I chose to believe it.
But
Not, or to disbelieve it.
But you chose not to disbelieve him, right?
Objection, double negative on the question.
And rephrase.
You chose not to believe him.
I guess you would say that I did choose
No.
not to believe him.
What I say doesn't matter. You chose not to believe him, correct?
Once again, because of other information, not simply because of this.
So the answer is yes. Is it?
Yes, with a qualifier.
Understand. Now, the other individuals that are involved in this case, for example,
Mr. Martinez, we're going to take the noon recess at this time. All right, ladies and gentlemen, please be back in the designated area at 1:25. Please remember the admonition. You are excused. Have a nice lunch. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue. Yes. Ladies and gentlemen, before Mr. Martinez continues with cross-examination, one of the jurors requested April 22nd as a date when we would not have court because of a previous commitment. I've spoken with the attorneys and we have agreed that we will not have court on April 22nd to accommodate the juror. All right? Mr. Martinez, you may continue.
and we were talking about some of the conversations that you passed judgment on. Specifically, we talked about the one involving Reagan. We talked about the one involving Shatanya Lay. Do you remember that?
Yes, sir.
And in fact, there were other people that we read either instant messages or text messages, and you made some judgments on them. For example, Denise, you made some judgments based on what you read about her, correct?
Yes.
And specifically, you also indicated with that one that she was vulnerable and that there was some flirtation that was going on between the two of them, right?
I'm not sure that I said she was vulnerable. I said most of the women were vulnerable.
Well, no, I'm asking specifically about Denise. Do you remember saying specifically that she was vulnerable, yes or no?
I don't recall that I said that.
You
I may have said that, but I don't recall.
And you testified to that. You spoke about that. Do you remember that you spoke about it on Thursday?
Yes.
You just don't remember what you said.
I don't remember if I said she was vulnerable or that most of the women were vulnerable.
All right. But you may have said that she was vulnerable, right?
I may have said that.
And with regard to somebody named Nicole, again, you talked about being flirtatious and that sort of thing, right?
Yes.
Same thing with Michelle. You indicated that she was vulnerable. Do you remember saying that?
Who?
Michelle.
No.
You don't remember?
There was Chriselle, but not Michelle. There was not a Michelle.
So Chriselle, you do remember that she was vulnerable, right?
Correct.
And basically what you're telling us is that as to all these people, you're able to make these judgments without ever having spoken to a single one of them, right?
I've gone on the context of what they've said repeatedly in their conversations with Mr. Alexander.
So is that you haven't spoken to any of them, correct?
I have not spoken to any of them.
And yet you reached an opinion, correct?
Yes, I did.
And this opinion was based on writings, correct?
Yes, it was.
In fact, that's something like ask the question involving Snow White when you indicated that there was a question as to whether or not she was a woman who was being battered, or whatever the term was. Do you remember that we've talked about it?
I'm not sure I'm not understanding what you mean in terms of the
Do you remember
correlation.
Do you remember that you presented on whether or not Snow White was a battered woman? Do you remember that?
I didn't present on whether she was a battered woman. I presented about gender, and Snow White was the character I used.
But your title did indicate that, right?
My title, as I've said numerous times, was a catchy title.
Right. In other words, it was not the truth, is not what you're telling us, right?
I'm telling you that it was a catchy title that embodied the speech I gave, which was about gender and power. And the jury might have to see the entire speech to get the context, Mr. Martinez.
I'm just asking whether or not that was the title, right?
That was the title.
And now you're telling us that this title that you helped craft, right?
Yes, I did.
That this title really was not what you presented on, right?
It was a part of looking at gender and the impact of gender on domestic violence as well, and the impact of what people learn about their gender in regard to domestic violence. So if you take it out of context, you can make it look any way you want to, but if you look at the context, it would make perfect sense to you.
Well, I'm looking at in context. Did you address whether or not in that presentation Snow White was a victim of being a battered woman?
I talked about her gender and growing up.
So you didn't, is what you're telling me.
Once again, you need to look at the context, Mr. Martinez, and you want me to take things out of context, and I think that's an unfair representation, frankly.
Well, you were there, correct? At the presentation?
I was not only there, it was enjoyed by many people.
I'm not asking you whether it was enjoyed by many people, did I? Did I?
No, you did not.
I'm asking you whether or not you were there. You were there, correct?
I presented.
And you picked the title, right?
I picked the title along with the people that who thought it was a great title.
I'm just asking, so what you seem to be indicating is that you don't want to take responsibility for picking the title.
Okay, I'll take responsibility. I will happily take responsibility.
Excuse me. Did you pick the title, yes or no?
I picked it, yes.
And you were there, you picked the title, you presented. My question to you is, in that presentation, did you make a decision, or did you reach a conclusion, or did you even address whether or not Snow White was a battered woman, yes or no?
I addressed the issue of people growing up being trained like Snow White, that they could go into abusive relationships, and why we would expect them to be one way or the other. But once again, it's the context, Mr. Martinez, and you want me to say something that really doesn't characterize what I did.
Being non-responsive and speculating.
Sustained. Listen
So, ma'am.
to the question, don't volunteer information.
All right.
So, and you made that presentation, or you were there at that presentation, and you were the person that was presenting, even though you never spoke to anybody involved in the Snow White tale, correct?
Objection, relevance, regulation, foundation.
Overruled, you may answer.
I didn't speak to the Seven Dwarfs or Snow White. I'm not sure who.
Yes, that's the question. Did you speak to anybody involved with this fantastical tale?
I think that answer would be quite obvious, that I couldn't speak to Snow White, nor could I speak to the Seven Dwarfs.
So would that be no then?
Okay, that would be no.
And just like the people here, Denise, Nicole, Lisa, Deanna, Michelle, Reagan, Shatanya, and Maria, I'm sorry, Chriselle, Reagan, Shatanya, and Maria, you didn't speak to them either, right?
No, I did not.
And it's the same sort of analysis that you applied to Snow White as you did to the writings of these individuals, right?
No.
Well, you used your brain in terms of, and although it may seem obvious, you didn't use the exhibit number 558, right?
I said I used that in part.
So you did use that in part in your presentation,
I said that, yes.
involving Snow White, then, right?
Oh, no, not involving Snow White. That was not part of the presentation, Snow White.
And involving Denise, Nicole, Lisa, and all the other women, you didn't use this exhibit 558 either, did you?
I used the framework.
And again, the framework comes from your mind, right?
Actually, it comes from reading other people who opine on the subject, who have lots of experience, and my own 35 years, almost 35 years of experience.
Didn't you tell us that when you were making an assessment in this case, that it actually came from your brain, that you actually didn't have to consult this exhibit 558 in making the assessment in this case?
It came from my trained brain.
It came from your thought process, right?
It came from my trained brain.
Right. You thought about it, right?
I thought about it and used other materials
Right.
to.
But one of the materials that you didn't use was this exhibit 558, right?
Objection was carried for testimony.
Overruled, to me answer.
I'm confused about what
All
you're
right, then.
asking me.
In your assessment in this case, you just told us that you used your trained brain, right?
Yes,
That trained brain incorporated 558, right?
correct.
What you're telling us is that you didn't look at it specifically, right? You just thought about it, right?
I probably looked at it too, but I mean, I've looked at it over time, so I'm not sure. It's in my head. When I discussed it with the jury, I discussed it from my head, not from the paper in particular.
But of course, you did use the paper when you were discussing it, though, right?
I rarely looked at it because I know it.
So the answer is yes, you did use the paper.
I used the paper.
And Matt, one of the things that when we're talking about this,
Objection, which part of the last part of our answer was overspoken. We didn't get the rest of it.
Yes, you may complete your answer if you did not.
That I had it up there, but that I know it well enough that I can discuss it without having to continually refer to it.
it's the same thing, though, whether or not you have it up there on the screen or have it in your brain. It's the same thing. It's the same guide, correct?
Yes,
And with regard to this guide that you have in your brain, for example, this is, in assessing these cases, you do have this continuum, and you have your experiences, right? When you're assessing a case, right?
I have the total context of what I'm looking at, yes.
I'm not asking that. What I'm asking is what you bring to the table, not what the table has there to provide you.
All right.
In other words, you bring your education, right?
Yes,
You bring this continuum, right?
yes,
And you bring your experience, right?
with both victims and perpetrators, right?
So the answer is yes, you do bring your experience, correct?
Yes,
And even though you bring all of that to the table, there is no standard that we can point to, for example, up on the screen or on a piece of paper that we can say, this expert found, based on this particular standard, found something. Your standard is not written anywhere, correct?
Untrue. My standard is published and it's being used by attorneys. It's being used by 730 evaluators. It's being used, it's published in Canada because they thought it was useful. It's published in 2 books by 2 different authors.
So is this part of your standard, Exhibit 558?
That's what I'm talking about. Yes, that's been used by other
That's
people.
your standard though, right? Is this your standard, 558, that you go by?
I don't go by one standard. This is one tool that I
Right.
use, but I'm not sure what you mean as a standard, Mr. Martinez.
Your approach to these cases is subjective, isn't it? It's what you believe.
I try to make it as objective as I can by using evidence, Mr. Martinez.
I understand that you try, but it's still a subjective sort of approach, isn't it?
Probably not any more subjective than any investigation with a police officer or anybody else. You take the evidence that you have and you weigh that evidence based on a lot of things. And so I don't think there's anybody who has a purely objective view. And so I would say that if you're a police officer, you bring that to the table. If you're an attorney, you bring that to the table, your view to the table. And so, yes, in that way, I'm bringing my view to the table.
So you're saying that your approach is the same as DNA evidence, now that you're talking about police. Same certainty applies to your opinion as it does to DNA evidence.
No, I'm not saying that.
It doesn't, does it? Because that has a standard, an objective standard that people can go out and retest if they wanted to, right?
There's decomposition in DNA standards.
Are you an expert in DNA, Nick?
No, but I've read.
Right, but you're not an expert, right?
No, I'm not.
So in terms of a sample that's not biodegraded, and you have all of the loci that match, if we're going to talk about that, and those, you get a profile, correct?
Wait, me or DNA?
Objection, Judge. She just said she's not an expert in DNA.
Overruled.
In a DNA test, you get a profile, don't you?
I don't know.
So then why, if you don't know about this test, do you want to now tell us about a biodegradable substance?
I'm only saying what I've heard in trials.
Right, but you are not, in a sense, telling us that.
And there is a profile. There is I don't know enough to be an expert, but I know enough to know something, and probably people who watch CSI know enough to say something.
The issue that I'm presenting, or the question that I'm presenting to you is, isn't it true that your approach does not have the certainty that would allow an independent individual, somebody else, to go back and start the investigation again and reach the same results that you would, right?
I don't know.
Well, is it like a DNA test, your approach?
No, it isn't.
Is it like a blood test, your approach?
No, it isn't.
And your approach, is it even a little lower than that? You are familiar with what psychologists do, right?
Are you talking about testing?
No, I'm just familiar. Are you familiar with what they do? What kind of work they do?
Psychologists?
Yes.
Well, and what are you referring to?
I'm referring to the field of forensics. You're here as a forensics expert, aren't you?
I'm here as a domestic violence expert.
Well, but forensic means that you present it in court. You understand that, right?
I know that. But
Right.
there are a lot of psychologists who don't present in court.
I understand that, but I'm asking you if you're familiar generally with the job that a psychologist does.
Objection made, foundation.
Approach.
You may continue.
Are you familiar with what psychologists do in the forensic field?
Much of what they do involves testing.
So you are familiar with what they do, correct?
I think the difference between what they do and what I do is testing primarily.
And what you do basically, ma'am, is you sit and you talk to people, right? Because you don't test, correct?
Correct.
And you read things, correct?
I do.
And in fact, one could say that you are a counselor, correct?
I'm a psychotherapist, yes.
But basically what we're really talking about when we break it down is that you're a counselor, right?
I'm a psychotherapist by profession, Mr. Martinez.
And you don't do any testing, right?
No, I don't.
So that we couldn't go out and take a look at your raw data or whatever answers were provided so that somebody else could examine them, right?
Correct.
All we have to rely on with you is what you tell us is your interpretation of what you've read and what you've heard, correct?
That would be true. And in addition to that, I would just say that testing is somewhat subjective too. And it is, when you look at testing, the caveat with testing is this should not be used to stand alone. This should be used in conjunction with the things that you're talking about that I do, if it's used.
But you don't do any testing, do you?
No, I don't.
You're not an expert in testing, are you?
No.
So what you just told us now, in a sense, is you haven't had the schooling that would allow you to make the statements as it applies to these tests, right?
I work with people who do the tests, and we work in conjunction, and so we go over testing together. But do I do testing? No, I don't do testing.
And that's left for others that have a higher degree than you, correct?
Sure.
And when you are evaluating a case, but what you do is basically, as we said before, you sit down and you hear what people have to say, then you look at what they've written, and in a sense, you have to make a call as to whether or not you are going to believe the written word or believe the spoken word, correct?
No, that's not true.
Well,
I can believe both or not believe both. I turn down cases where I find...
Judge, non-responsive. Ma'am, I'm asking you in terms of your analysis, isn't it true that to further your analysis, you're acting as a gatekeeper in the sense that you choose to believe something or you choose to disbelieve something depending on what you think?
No, depending on the evidence, Mr. Martinez.
I agree that you have items in front of you, but you would agree with me that others may see something differently than you, correct?
That's possible, sure.
So that, for example, if you choose to believe somebody, somebody else may choose to disbelieve them, right?
If I choose to believe somebody, that somebody else could disbelieve it. Yes,
Correct.
that's possible.
So that's the type of approach that you used in this case, right?
I gathered evidence, Mr. Martinez. I don't know what to say. I took a lot of evidence. I read a lot of materials. I did a lot of interviewing. I read a lot of collateral sources. And that's how I came up with a decision that I came to even testify in this case.
Can we agree now that you did read a lot, that you talked to one person, and that you then came to your conclusion? We can agree to that. All right? Given that, isn't it true that even though you have all of that, isn't it true that it's still what your opinion is that cannot be verified that we are talking about today?
That cannot be verified.
Correct. We cannot, for example, go in and input it into a computer and get a result, right?
I have no idea. I'm not good with computers. I don't know when you put, FBI's people profile, and they don't have They have a lot of information and they put it together and they create a profile that you can agree with or not agree with. But that profile is inputted into a computer and they look at it and they look at, and there's a lot of information that is looked at in terms of domestic violence where people have taken data and put it together. So I'm just not exactly sure where you want me to go with this, but this is, for me, the truth of it.
Ma'am, with regard to profilers, do you know whether or not that evidence is admissible in court? Yes or no?
No, I don't.
So you're giving us an example of somebody that is giving an opinion, right? The profiler is giving an opinion, correct?
Correct.
And that opinion is used sometimes by law enforcement, right?
Yes.
And that opinion can be wrong and it can be right depending on the profiler, right?
Correct.
And it can be wrong 100% of the time because it depends on what the person that is profiling is thinking, right?
I don't think it's just a matter of what they're thinking. I think it's their experience. I think it's what they're reviewing. I think it's a lot of things.
Sure, but you can't input what their information is into a computer and come up with a name, for example, of the person who committed the crime, right? If you're a profiler.
If you're a profiler, you might be able to come up with a collection. I don't know, Mr. Martinez. This is really not my expertise. I'm just simply saying that there's groups of people that put information together and they get things out on a computer. I'm not one of those people because I'm not a computer whiz.
With regard to whether or not you're a computer whiz or not, even if you were a computer whiz, there is no way that your approach would fit a computer, would it? There's no way to input it into a computer and come up with a verifiable result, right?
Objection, foundation, and knowledge.
Overruled. Me answer.
I really don't know.
And with regard to the profiler, it is true that you're the one that brought that up as an example, correct?
Yes, I did.
Ma'am, one of the things that you keep talking to me about is context. You always, or in the morning you talk to me about context, right?
Correct.
And you've indicated that it's really important in determining whether or not you are going to make an assessment one way or the other, right?
Correct.
And we have exhibit number 444, which is a series of text messages. And this involves an individual by the name of Michelle K. and Mr. Alexander wanting to know about this information that this Michelle K. may have provided to the defendant, right?
Objection, Judge, foundation, give me the time and date of what we're referring to.
Yes.
It's exhibit number 444.
Right. The text messages are dated.
Judge, it's improper. Her objection is improper. If she doesn't understand, that's the problem, not her.
May we approach?
You may approach. Sustained.
You remember talking about this text message to us? Yes or no?
Yes, but the name is incorrect.
I understand that you say the name is incorrect. All I'm asking you, man, is whether or not you remember talking to us about this text message. Yes or no?
Yes.
And the date on it, it's halfway down, is April 7th of 2008. You see that?
Yes.
And you're saying, well, the name there is incorrect, right?
Yes.
And you're talking about either Michelle or Elena, right? One of those names, according to you, even though you weren't there, is incorrect, right?
According to the information I received.
I understand that that's what you are relying on. But according to you, you chose to make a decision based on what somebody else may have told you or what you may have read to make a determination here, right?
Objection,
Overruled.
Right?
Yes.
And somebody else could have come up with a different conclusion than you, couldn't they?
About the name?
Yeah, about the name.
I guess.
Sure, because there's nothing really scientific about that approach, is there?
About what approach?
Your approach in making a determination as to which name is accurate.
No, I suppose there isn't.
And ma'am, one of the things that we know is that Mr. Alexander is talking about a BS story, right?
Yes,
And he's talking about this BS story about somebody coming over to where the defendant worked, right?
yes,
And this woman came over to Ruby Tuesdays, correct?
yes,
And this woman came up to the defendant, right?
yes,
And this woman came up to the defendant and divulged that Mr. Alexander had been having a relationship with Lisa Andrews for a period of time, right?
correct.
And so in terms of context, that's something that we can consider. The fact that the defendant is the one that told you about that, right?
Yes,
She's the one that told you the name of the restaurant, right?
yes,
And you're the one that sat down in your notes and you wrote it down, right?
yes,
And additionally, you decided to adopt the story as true, right? In other words, you believe the defendant when she told you that somebody came to this restaurant and told her about the relationship with Lisa, right?
that was not a real significant piece of information for me, Mr. Martinez.
I understand that you may say that now, but it is something that was significant enough for you to write down, correct?
I wrote lots of things down.
So is that yes or no?
It's neither. It's
Well,
just a thing I wrote down. I write notes to myself. It was significant enough, I suppose, to write it down, but whether it was significant enough it's something I wrote down.
Yes, you did write it down, and it is part of your notes, correct?
Yes,
And you try to be as accurate as you possibly can with your notes, don't you?
yes,
And if something strikes you, that's when you write it down, correct?
if it's something I have a question about,
Or even if you don't have a question about it, it's something that you write down, right? If
yes,
it's important enough to you, right? So you say, take a look at the context of this. The context of this is that the defendant is working at what restaurant again?
I believe it's Ruby Tuesdays, but I'm not certain about where she worked, and that is not as significant as lots of things.
She's working at this restaurant, and while working at this restaurant, some individual who supposedly knows both of them comes in and gives her this story about Mr. Alexander, right?
Correct.
And in your view, who was that individual, man?
A woman by the name of Maria.
Maria what?
I have no idea.
Did you ask her?
Marie. No, her last name was not significant to me.
So, well, we do have Maria written down here, or no, we have Michelle and Elena, but you believe it, those are both wrong, right?
No, I don't know anything about Elena.
So if the defendant told Mr. Alexander that it was Michelle or Elena, after talking to the defendant, you have a different name, right?
I have the name Marie.
Right. So you would agree then that we have three potentially different names that were given to Mr. Alexander.
Objection, mischaracterizing the testimony.
Overruled, you may answer.
I don't think Marie was given to him because I think he said Michelle here.
Well-
but I don't know.
Well, but if the name was Marie was given, then it is true then that the name Michelle, if that's the name that she gave Mr. Alexander, which indicates that she did, that would be a lie, correct?
No.
Oh, so
Could be.
Marie,
I'm not sure what you're saying, but what I'm saying is that it could be a mistake that he wrote Michelle down, and it could have been Marie. I don't know.
and that illustrates the problem with just reading, correct? Because you don't know what's going on when the person is writing, right?
This is not the only thing I look at, Mr.
I
Martinez.
understand that, but I'm asking you a direct question. Isn't it true that you've just given us an example of why you don't just rely on writing, right?
I think that I rely, if I have a preponderance of writing that is consistent, I can rely on that writing, especially when I don't have other things. I can't interview Mr. Alexander, although I read what he wrote about his life, and I read some things in his journal, and I read an email from his sister. So I really tried to look not only at Ms. Arias's perspective, but also at the perspective or the things that Mr. Alexander wrote that I had opportunity to read.
Are you done with your answer?
Yes, I am.
Now answer my question. Haven't you just illustrated for us one of the flaws in just relying on what somebody has written?
That a name can be different?
No, that people can write something by mistake. You were imputing that mistake to Mr. Alexander, weren't you?
One of them made a mistake.
Well, no, ma'am. Didn't you just say to me earlier, oh, well, Mr. Alexander could have made a mistake,
I
right?
said he could have.
Right. So the mistake, if there is one, according to you, it was Mr. Alexander's. It wasn't the defendant's, right?
No, I said he could have made a mistake.
Right.
I don't know if her name was Maria or Marie or Michelle, but the name of somebody is not nearly as important to me as the rest of it. I don't know why that name is so important to you, frankly.
Ma'am, would you admonish the witness about responses like that? About what made me...
Don't volunteer information. You may continue.
Ma'am, my question to you is not about the names. It's just illustrative. My question to you is, isn't it true that just relying on the written word is a situation, as you've illustrated, that could create mistakes, right?
If you only rely on one written word.
Even if you rely on 200 different items, isn't it true that mistakes can be made in the writing, correct?
Yes.
And you just illustrated it for us right here when you told us, well, this could be a mistake. And why did you choose to place the blame or the mistake on Mr. Alexander rather than on the defendant? Why did you choose to do it that way? Why did you choose to make him the person that made the mistake?
I didn't choose to make him. I said it could have been. I didn't focus on this as some key issue, the name of the person that I needed to focus on, Mr. Martinez.
My question to you is, why didn't you say that it could have been the defendant that gave him a lie, gave him the wrong name?
Objection is characterized as testimony.
Sustained.
Why didn't you tell us? You didn't tell us that it was the defendant that could have given him that name, did you?
Same objection, Judge. Same question.
Overruled. You may answer yes or no.
I could say that to you now if you like.
Ma'am, Judge, it's just not being responsive. If you could please admonish her.
Overruled. Ask another question.
Ma'am, it appears just from that exchange that you have a bias here, don't you? You have a bias in favor of the defendant and against Mr. Alexander just by this minor example, don't you?
No, I don't.
You immediately, your fallback position here wasn't the defendant lied, your fallback position was Mr. Alexander made a mistake, could have made a mistake, right?
My decision is not based on this I am, Mr. Martinez. You mischaracterize what I say, and I'm going to repeat what I say.
Did I mischaracterize your statement when you said that that Mr. Alexander could have made a mistake? Did I mischaracterize?
I did say that. Yes, I did.
And, ma'am, you're familiar with, at least in your reading, with somebody by the name of Matthew McCart, right?
Yes, I am.
And you're familiar how it was that the defendant found out that Mr. McCartney may be involved with another individual, right?
I don't know how she found out, but I do know that she found out.
Are you familiar with somebody by the name of Bianca in this story?
Yes.
In terms of Bianca, do you know how it was that the defendant came to know about Bianca and what she did in response to that?
I don't know how she found out about Bianca, but I know that what she did in response to that.
Well, isn't it true, I'm asking you whether or not you know this, that the defendant happened to be working at another fast food place, not a fast food place, another restaurant, this one called Applebee's. And while she was working at Applebee's, two girls came in.
Said. No.
Approach.
Sustained.
Yes.
Ma'am, please take a look at this. This is the defendant's testimony of February 5, 2013. Please read it to yourself, and once you're done reading it, let me know.
Okay.
Ma'am, what's the exhibit on there? 600? What? Something.
601.
601.
I don't have the first answer. I don't
Please
have a
read
question.
it. Please read it. Just please read it.
Okay.
If I may have it back. The defendant there does testify that she was working on Applebee's.
Yes.
And while she was working at Applebee's, it seems that two women came up to her, correct?
Yes.
And these two women told her that Matt McCartney was dating somebody else named Bianca, correct?
Correct.
And as a result of that, she then went and did whatever it was that she did, correct?
Yes.
Doesn't it seem strange? Well, doesn't it raise a red flag to you? Well, let me do it this way. The defendant has had 4 significant relationships, correct?
Correct.
One of them is Bobby Juarez, correct?
Yes.
Matthew McCartney,
Correct.
Daryl Brewer,
Yes.
and Travis Alexander, right?
Yes.
Doesn't it raise a red flag to you that in 50% of those, 2 of the 4, somebody would come in, a female, would come in to the place where the defendant was working and tell her about her boyfriend being unfaithful?
Objection, Judge, this characterizing the prior testimony of Ms. Arias. Judge, may we approach with the transcript, please?
Yes. Sustained.
Now, let's get this way. Doesn't it raise a red flag to you? The defendant is working in both of these circumstances at restaurants. And in both circumstances, people come up to her and tell her that her boyfriend is cheating on her. Does that raise a red flag for you?
It's the first I've heard about the other.
I understand this may be the first time you've heard of it, but we're talking context, right?
So I'd need to think about it and I'd need to get clarification on it.
And it also illustrates the point that your opinion, whatever it may be in this case, is incomplete, right?
Not my opinion about domestic violence.
Well, you are not receiving the full information. In other words, you spoke to the defendant for 44 hours, right?
Yes.
And during that time, this issue of Applebee's and two people coming up to her and telling her about her boyfriend never came up, right?
I was looking for domestic violence issues, Mr. Martinez. And
So-
so no, it didn't come up.
So in other words, you were so focused that you ignored what was going on?
No, I didn't ignore what was going on. I got lots of information. That was just a piece of information I didn't get.
But you are an expert though, right? In the field of domestic violence, right?
Yes.
And you've testified about your opinion based on writings and on the statements of the defendant, right?
Right.
This is just another statement of the defendant that the state is asking you to consider that she testified to. And I'm asking you, doesn't it seem a little strange to you that in 50% of her relationships, she's working at a restaurant when somebody, either one or two people, come up to her and tell her about her boyfriend cheating? Doesn't that raise a red flag for you?
I really would want to get clarification. First of all, she worked in restaurants most of the time, so that she worked in a restaurant isn't the issue. What you're asking me is, I think, is if it's strange that people would come up. Is that what you're asking me?
No, I'm asking you, isn't it strange to you that the defendant is working at a restaurant in Mesa, the first one, involving Lisa Andrews? You know about that one, right?
Yes, the one that's on the screen, right?
It's Ruby Tuesdays. You told me about that, right?
The one that's you're referring to on the screen.
Correct. Mesa, you may not be familiar. It's a pretty big city, don't you think?
I
You don't know.
haven't lived in Arizona for a long time.
You don't know, is what you're saying.
I don't.
Correct? Flying in, you saw Phoenix was a pretty big place, though, right?
Yes, it is.
It's not like it's a very small place where everybody knows each other, right?
No.
And in that circumstance, somebody comes in and speaks to the defendant and tells her about Mr. Alexander. That's what she told you, right?
Yes.
Out of all these places where people can work, out of all these hours that people work, somebody was able to find her there and tell her this, right? This information, right? About Lisa Andrews, right?
Sounds purposeful on the part of the person who told her.
And there you are again interpreting what the person may have done, correct? That it was purposeful, right?
That it may have been purposeful.
It could also be a lie, right? That this person actually came to Miss Arias, right? It could also be a lie, right?
Are you asking me if I believe Miss Arias has a history of lying? I'm not sure.
She does have a history of lying, doesn't she?
After the killing, yes.
And she has a history, well, she has a history of lying, but you're saying, well, this happened after the killing, that you got the statement from her, right?
She doesn't have a history of lying prior to the killing, no.
I'm not asking you about a history prior. I'm asking about a history after. Isn't it true that this conversation that she had with you involving Lisa and Ruby Tuesdays happened with you after the killing, right?
Yes, but the text happened prior.
I understand that the text happened prior, but she's telling you the story afterwards, right?
Yes.
When you say she has a history of lying, right?
Objection is characterized with regard to history of lying.
Sustained.
Did you tell me that Miss Arias has a history of lying after the murder? Or after the killing, I apologize.
She lied about the killing. I don't know that she has a history of lying about anything else except the killing. And I do know she has that she lied about that, and she confessed to lying about that.
Well, but in terms of everything that happened afterwards, are you aware of what she did afterwards? In terms of what may or may not be truthful?
I know some of the things she did afterwards, yes.
So in this case, because of that as a background, and the fact that we're talking about two instances where people come in to where she's working and find her and tell her things, that, again, you're the expert. Doesn't that seem a little bit strange that 50% of her relationships, somebody's got to drop the dime in a restaurant while she's working?
I don't know. I really don't know how to answer that. I really don't. I don't know. I mean, I know people do things. I know people have gone and talked to people. I have lots of clients where people have gone and told them things. So I don't know how to answer that for you.
And you don't know how to answer it because you don't know whether or not that's the truth, right? You don't know if it's the truth, do you?
Which is the truth?
What we're talking about, that some people came to see the defendant while she was working. You don't know if that's the truth. That's what you're telling me right now, right?
I don't know. I don't know that what Miss Arias told me is the truth. Is that what you're saying?
Right. In terms of the Applebee's story, you don't know if that's the truth, do you?
No, I don't.
Same thing with regard to the Ruby Tuesday story. You don't know if that's the truth either, do you?
No.
So, if we're then talking about context and we're talking about this anger that we see from Mr. Alexander, he's the one that's been having this relationship with the defendant, right?
Yes.
And if this individual, this defendant, starts doing things just like what we've seen here, this minor example, about saying things like this, then this text message might indicate that he's probably justified in questioning her in this manner when she's...
Recommended compound question.
Restate your question.
Ma'am, you can't tell us that Mr. Alexander was out of line given the context that we just talked about here.
Objection, argumentative. Speculation as well. Asking for speculation.
Overruled.
The only person I see who has a history of lying so far is Mr. Alexander. I haven't seen that in her history prior. I mean, you're asking me to say, could he be justified in a hypothetical that hasn't fit with what I've read? Yes, he could be justified in what I've read in terms of lying. I don't get that Miss Arias, with prior boyfriends, has lied.
With regard to this abuse, you indicated that this text message is one of the things that you considered in making your determination that Mr. Alexander was abusive to the defendant, right?
Could you
Sure.
look that up?
Sure.
That I said that this was one of the things that indicated that he was abusive?
So that you consider making your determination that Mr. Alexander was abusive.
Yeah.
That witness is being charged.
Yes.
Exhibit number 444. This is something you considered, right?
That was something I read.
Well, reading and considering are two different things. Is this something that you considered in making your opinion or reaching your opinion that Mr. Alexander was abusive?
It wasn't a major thing I considered. It was something I considered for sure.
Right. And so if, for example, Mr. Alexander, hypothetically speaking, if he's the one that wants to know about this person that may have come in, and in light of the context that I have provided you, it doesn't seem that his conduct in asking her details about this individual is so out of line, is it?
Objection, speculation.
It doesn't look like he, okay.
Approach, please. Overruled.
Hypothetically speaking, in this particular case, Mr. Alexander is saying,
Would you mind, thank you.
I'm going to do it.
Okay, thank you.
He's saying, you insult me by thinking I'll believe such crap. And the crap that he's talking about is somebody coming into Ruby Tuesdays and telling the defendant something about him and another woman, right?
Would you put that up on the screen again, please?
Objection for speculation as to what Mr. Alexander specifically meant when he's wording something here.
Sustained if
Well, ma'am, look at the top. And do you remember testifying about this the other day?
Yes,
And do you remember testifying the other day that this had to do with somebody coming over to the defendant's work and telling her about Mr. Alexander dating Lisa Anders? Do you remember you told us that?
yes,
You had no misunderstanding then about what this was about, right?
correct,
This is one continuous text message, right?
correct,
So it's dealing with the same subject, correct?
correct.
And so when he says, you insult me by thinking I'll believe such crap. I already know you're lying, so why continue? He's questioning this story of somebody coming over to her workplace and telling her about Lisa Andrews, right?
Objection, speculation, especially. May we approach?
may approach.
And with regard to Exhibit 444, and in light of your previous testimony, what is your understanding that Mr. Alexander is talking about when he says, "You insult me by thinking I'll believe such crap. I already know you're lying, so why continue?" What is your understanding that he's talking about?
That he doesn't believe her
About what?
about the information regarding the woman who comes in to talk. But part of what I considered, in the context I considered it in,
Judge,
was
now
that
she's
she had
beyond the scope of the
also,
question.
Right. Proceed.
Okay, so ma'am, now that he's saying that, and in light of what you know now about the Applebee's encounter, this is the one in California, remember that one?
Yes.
Involving Matt McCartney. Wouldn't it seem to you, or wouldn't it raise a flag to you about the defendant's veracity or truthfulness that this same story is being told with regard to two separate men that she's dating?
I would check this story out.
But you didn't in this case, did you? Before you came in and gave us your opinion.
I didn't know about the Applebee's story.
Right, and that means that your assessment is incomplete, right?
No, it doesn't.
Ma'am, the other text messages,
And by the way, in that text
yes,
message,
there is no question.
right.
Ma'am, in exhibit number 448, there's an issue involving a text message that was inadvertently sent by the defendant. That was meant for somebody else, and Mr. Alexander actually received it, right?
Correct.
And in this one, he gets upset about it, right?
Right.
And he calls it a Steve cover-up. Isn't that what he calls it? You see that there?
Yes.
And if you want to see the date, it's there. We know that the times are off. It's May 10th of 2008, right?
What exhibit number?
448. You see that?
Yes.
Now, with regard to this particular set of text messages, what is your understanding about whether or not the defendant sent the second text message that Mr. Alexander is requesting?
I'm not sure what you're referring to.
You remember you testified about this, right?
Objection.
I testified about what was said. The way things are said in this, as
I've asked her
opposed
whether or not
to...
she remembers testifying about it, not anything else.
Sustained. Can you answer yes or no?
I can answer yes with a qualifier.
All right. Next question.
All right. And in fact, this was provided to you to review as part of your testimony when you testified to it, right?
Yes.
So, as we sit here today, you've now testified about it. Do you know whether or not the defendant actually provided the second portion or the second text message that's associated with the first one?
I'm not sure.
You're not sure?
Allow me to read the rest of it.
I understand that. All right, I'll let you take a look at it and then we'll talk about it, okay?
Okay.
did she provide the second portion?
Doesn't appear that she did.
And if she didn't provide the second portion of the text message, it appears that, or not appears, she's standing up for herself, right? He's not going to push her into providing the second part of the text message, right?
I didn't testify to that.
I'm asking you, isn't it true that since he couldn't get her to provide the second text message, that means she's able to stand up to him, right?
I don't know.
Well, at least on this occasion, since she didn't provide it, she stood up to him, didn't she?
She placated him throughout that.
I understand that you're using the word placated, but isn't it true that another word for placate in this circumstance is she stood up to him and didn't do it, right?
She didn't do it.
That means she stood up to him, right?
I guess.
Well, you're the expert. Isn't that a step in standing up to somebody when they say to you, the supposed abuser says to you, I want this, and doesn't do it? That's standing up to him, isn't it? Even if they're going to incur their wrath.
She incurred a lot of wrath in that.
Ma'am, I'm not asking you about how much wrath she incurred. Isn't it true that she stood up to it?
It appears that she stood up to him.
And in fact, do you know whether or not there is, take a look at, this is the first text message. You see that, the one at the top? Hey there, someone has my Google password because he's helping me with some things on my Google blog. Unfortunately, he happens to be an ex-boyfriend. Do you see that?
Yes.
Do you know whether or not she actually provided another text message associated with this first text message?
To whom?
To Mr. Alexander.
No, I don't.
And in fact, hypothetically speaking, had she failed to not only provide this, but made another one up, wouldn't that be significant to you, hypothetically speaking?
Approach.
Sustained.
Hypothetically speaking, let's assume that Ms. Arias then created another text message just like that and sent it out to Mr. Alexander, representing that it was this one. Would that be of significance to you?
I have no evidence of that hypothetical, Mr. Martinez.
Ma'am, we do. She testified to it.
All right.
Objection. She didn't hear her testimony.
I didn't hear the testimony.
Would that make a difference to you if she had said it?
What made a difference to me, Mr. Martinez, was the reaction to whatever happened, the overreaction to whatever happened, the names that were called. That was when I took this, that's what I looked at. Not that he didn't have a right to be angry if there was a misunderstanding. Not that there wasn't a right for him to be angry, but the way he handles his anger was what I was looking at, Mr. Martinez.
My question to you, ma'am, would it make any difference to you that the defendant lied by creating another text message and representing it as being this one? Would that be significant to you?
Lying.
That was sustained. Rephrase.
Would it be significant to you, ma'am, if the defendant sent another text message instead of this one and represented it as being this one?
Sent an additional, I'm not sure what you're saying. Sent an addition, something other than this? Or?
Yes, and represented that it was this one that she had sent, and instead sent another one that she typed, or whatever it is that text message do, and sent that one and said, hey, this is the one that I actually sent. In other words, she created another one and held it out to be this one. Would that be significant to you?
Significant in terms of the big picture domestic violence, or significant how?
Significant in the fact that she's lying because she's misrepresenting something.
Objection is for mischaracterization as to lying. That was not her testimony.
Overruled, you may answer.
If she was lying,
Yes.
if I saw a pattern of her lying, it would be upsetting, and I would look at that pattern of lying. When I'm looking at her patterns here, Mr. Martinez, and I haven't seen the patterns in anything that I've read or anything that I've reviewed. So that's what I can tell you.
But for example, in the previous text message, you didn't know about the Applebee's incident, did you?
No, but I knew,
But and
I knew about what she did.
you knew about Applebee's and what she said happened in Applebee's? I thought you did.
No, I knew what she did afterwards, which was more significant to me.
And in this case, ma'am, isn't it true that, or what if the misrepresentation was such that, hypothetically speaking, if she said, well, I'm going to send you this one again because I don't have the second one. Wouldn't that, or the second portion of it, would that be significant to you?
Objection.
Overruled.
Would it be significant to me?
That she never sent the second portion of it, even though she could have.
Significant in what respect?
It characterizes the testimony that she could have.
All right, ladies and gentlemen, we're going to take the afternoon recess. Please be back in the designated area at 3:15. We will start promptly at that time. Please remember the admonition. You are excused. Council, please approach. Council, please approach. Mr. Martinez, you may continue.
Ma'am, Exhibit 448, we were talking about this message there. Do you see that?
Yes,
And then if we turn the page, or a couple of pages, we see the same message there, right?
yes,
You don't know how that got there, do you?
no.
Ma'am, in this case, you actually are biased in favor of the defendant, aren't you?
Do I believe the evidence that supports domestic violence? Yes.
No.
I think bias is an incorrect word, Mr. Martinez.
No, that is the correct word. Isn't it true that you are biased in favor of the defendant? Yes or no?
I don't believe I'm biased.
Ma'am, do you remember that the first thing that you did upon meeting the defendant when you went to visit her was that you apologized to her?
Yes, I did.
And you apologized to her because you had read some of the items that were involved in this case, hadn't you?
Yes,
And you had already formed an opinion with regard to those items that you had read, correct?
no, I hadn't.
Well, it's fair to say, though, that apologizing to somebody when it's the first thing that you do sort of seems like there's sympathy on your behalf for whatever it is that is going on with them, right?
Apologizing to someone for reading their most private thoughts and things that they thought they would never have in public is also a way to establish rapport so that somebody's really able to talk to you. And that's what I wanted. I wanted her to be able to talk to me.
But you actually meant the apology, though, didn't you?
Of course I meant the apology.
Right. So walking in, meaning the apology, one of the things that you did was indicate to her, I've already formed an opinion. I am sorry. Right?
Objection.
No,
Characterizes
not at all.
Overruled. The answer will stand.
No.
There was no need to apologize to her, was there?
From my perspective, there was a need to apologize.
So you felt so badly for her already that you felt there was a need to apologize then.
I felt badly that I had invaded her private most, ideas and thoughts that I'd read. It would be like reading my daughter's diary, I would apologize for that. I didn't, did that because I genuinely meant it, but I also did it because it's a way for her perhaps to trust me and to be able to tell me things that she might not tell me otherwise.
So with regard to this apology, is that an apology that you extend to each and every one of your clients that comes in?
I very seldom have read any, no, it isn't.
Yes or no? Do you apologize to your clients when they come in?
Objection. As for finishing her answer from prior.
Overruled.
I apologize to Miss Arias for reading private things. I don't.
Object is not responsive, Judge.
I don't, sorry.
Sustained. Repeat.
Do you apologize to your clients when they come in to visit you?
No, I don't know anything about them when they come in to visit me.
Ma'am, the answer is yes or no. You don't apologize.
It's not a complete answer, Mr. Martinez, and it's not a truthful answer, Mr. Martinez.
So what you're saying then is that you can't tell us if you apologize to your clients when they come in, or you can?
I tell you that I don't because I don't know their stories and I haven't read their private journals and I haven't read their private thoughts. And so I have no reason to apologize.
And knowing that you had read these thoughts, you felt so bad that you felt compelled to say you were sorry to the defendant, right?
I felt badly that I had read things that were never intended to be read by someone else, yes.
And feeling badly affected the way you viewed the defendant, didn't it?
No, it did not.
Well, if you feel badly about it, doesn't that mean that she's already got a little bit something on her side?
It means that I have apologized. It does not mean that I've apologized to clients if they've misunderstood what I said, but it doesn't mean I'm going to change the way I work with that client.
I'm not asking you whether or not you're going to work with that client. And the people that you work with, you are treating them, aren't you?
Yes.
You were treating the defendant, were you?
No, I was not.
There was no need to apologize if you're just going to assess it, is there?
My judgment said that would be something that I would do.
Where is it written in the rules, ma'am, or in any volume, anything that you can point me to, that you can say to me, when you first meet with a client in a forensic setting, you should apologize to them?
Objection, I admitted it.
I don't know that it's written anywhere, Mr. Martinez.
That's something that you did in this case, isn't it?
It's something I would do in any case where I felt the need to do it.
I'm not asking about any case. I'm asking about this case. You felt a need to do it because you felt sorry for her, right?
I wanted to do it because I invaded spaces that most people don't invade, and that I felt to establish a rapport, it would be a really good idea for her to understand that I understood that I was reading things that were never intended to be read by anybody else, and that if she knew that I knew that there would be a rapport there, and it did not bias because I had still made no decision about doing this case.
There are other ways to build rapport, isn't there?
There are many ways to build rapport.
And one of the ways to build rapport, of course, is to buy buy books for somebody, right? That's another way, right?
Sure.
And so when you're saying that you bought these books for her, that's just a way to build rapport, right?
I've done it for other people in jail.
Am I asking you whether or not you've done it for other people?
You're mischaracterizing what I do, Mr. Martinez, and I think it's really important for people to understand why I do what I do.
Oh, all right. Tell me what you don't understand about this question. Isn't it true that you bought some books for the defendant when she was in jail, correct?
Yes, it's true.
Isn't it true that this is the same defendant that you apologized to?
Yes.
Isn't it true that in order to build rapport with this defendant, you could have done other things, correct?
There are many things you can do. You don't stop building rapport because you do one thing.
I'm asking you, as a substitute for the apology, isn't it true that you could have built rapport a different way?
I suppose.
Well, didn't you tell us that humor was a way that you use in these domestic violence cases? Isn't that what you said?
If I walked in and made a joke with Miss Arias when I first met her, Mr. Martinez, that would have been so inappropriate and so counterintuitive to building rapport.
I'm not asking you whether or not you should have told a joke. Didn't I use the word humor, not joke?
How do you do humor when you first meet somebody who's been in jail for 4 years?
Ma'am, you're the person that's conducting the assessment, aren't you?
Exactly. And
And
so
our-
I get to decide how I build rapport, Mr.
And
Martinez.
that's right. But one of the things when you come into court, you get to decide what you do, but you also get to be questioned about it, right?
Exactly.
And one of the questions here is, why is it that you felt so strongly about her that you felt the need to coddle her by giving her books and apologizing?
Objection, argument that mischaracterizes her testimony.
Sustained.
Why is it that you felt the need to do that?
Same objection,
Overruled.
then vague.
I'm sorry?
Objection is vague then. Why did you feel the need to do that? Do what?
Overruled.
Do you want a complete answer?
I want an answer to my question.
Which,
Why did you feel a need to do that when you could have established rapport some other way?
I felt that that was a respectful way to talk to Miss Arias, as I do with anybody I work with. I find a respectful way to make a connection with them. I think it's important, and I think it's important for people to see that you have respect for them, regardless of what they're accused of, regardless of what they've done, that there is a respect that's basic to a human being. So I chose that way to do it. It was not something I had planned, Mr. Martinez. It's something that happened when I was there. I hadn't given it thought. I hadn't, said, gee, this is what I'm going to do when I see Miss Arias. I'm just going to apologize. It was something that I did when I was there. And when I purchased the books, and remember,
Judge,
I've
that's
been...
beyond the scope of the question.
Overruled to make initial response.
When I purchased the books for Miss Arias, remember, I've been on this case for 1.5 years. So during that time, I did that, and I've done that for other clients. I've done that for other people in jail because jail is boring, and jail oftentimes doesn't give people the opportunity to have their mind stimulated. And I've actually done it with people I don't know who've written to me from jail. I put together packets for them because that's part of what I do, and I see it as preventative, and I think in a preventative way. So.
Of those other cases of the individuals that were in jail, how many other times have you testified at trial in a criminal case?
At trial in a criminal case?
Yes.
I've testified.
I want a number.
I know you do, but I'm not certain. I wrote down how many I testified altogether, which is 18. This will be 19. Some of those are in family law. In murder cases, I've testified
Ma'am,
twice.
I just want a number. I don't want you to give me a free flow of expression. Please tell.
I'm not exactly sure. I would say it was less than 10.
And in those 10 cases where you testified in criminal trials, ma'am, of those, did you apologize to every one of those people before you went to, as soon as you went to see them?
I didn't read their most private. They were different. They were different. There's different reasons, Mr. Martinez. It's very different. You approach people the way I've done different things. I've reduced my fees in one of those cases because I knew that people didn't have a lot of money. So I do different things in different cases, Mr. Martinez. That's the way I work. I don't feel like there's just a rote way of handling people or one size fits all. I feel like it's important to look at the person that you're dealing with and try to deal with them based on who they are and not some formula.
Are you done? Or do you need to say anything else about that?
I'm done.
How many of those people that you testified in did you apologize on the first meeting?
Objection around this.
I don't know, one of them was 29 years ago, one was
Ma'am?
27 years ago. I don't know if I apologized or if I didn't. I don't. My first case was 84, and I remember going in and meeting with her in jail, and I don't know if I apologized. I can't imagine
Ma'am,
I
all you have to
did.
say is you don't know. You don't know? Is that what you're saying?
I would say unlikely because the circumstances were different.
So this is a different case where you could have shown respect a different way, right?
This case?
Yes.
This case seemed to me that was a really good way to show respect at the beginning.
I understand that that's what you say that you wanted to accomplish by apologizing, but there are different ways of showing respect, aren't there?
Sure.
You could have sat across from her and began talking to her about what happened in a very respectful way, couldn't you?
I did that.
Well, you could have done that, and that way that would have shown her that you were respectful, right?
Yes.
And in fact, you told us that 90% of all communication in a clinical setting is nonverbal, right?
Yes, I did. I'm really sorry I
Yes
said that, I guess.
or no.
Yes, I did tell you that.
So if you really wanted to show her the respect and show her that you were going to do this in a respectful manner, if 90% of the statements are nonverbal, you didn't have to say anything at all, did you?
Overall. Untrue.
So you felt that with regard to apologies, those are the only exceptions to your 90% rule.
No, that's not what I said.
Well, you did make the statement about the 90%, right?
90%, and generally speaking, you start by talking with somebody and connecting with them before they have a context to even assess your body language.
Well, ma'am, you spent 44 hours in this case, right?
Yes, I did.
So that was sufficient time in the beginning, at least, for her to assess your body language and that you felt respectful, correct?
Not the first 5 minutes when I met her, no, Mr. Martinez.
No one forced you to open your mouth those first 5 minutes and say, I am sorry, did they?
I'm not sure that I did it within the first 5 minutes, but I did it relatively soon, and nobody forced me. No, they did not.
And the 5 minutes that I just used, you were the one that just told me about it, right? That's the time that you told me, right?
I did not. I don't know that I did it within the first 5 minutes, Mr. Martinez. I don't know that I did that. What I do know is that I did it relatively soon, but that we had no basis for communication prior to that. So if I sat silently, that wouldn't have worked. Did I have to make an apology? Probably you could say no. I would say I thought it was a respectful and good thing to do. It was my decision to do it. So you can argue with that decision, but that's my decision, and I believe it was the right decision to make.
We believe that it was the right decision. But if your statement is true about the 90%, isn't it also true that, well, how long did you meet the first time with her? It wasn't 5 minutes and it wasn't 30, was it? It was more than that.
It was 8 hours, I believe.
Right, and in the first time that you met for 8 hours, you could have, through your body language, this 90% rule, after maybe 1 or 2 hours, attempted to convey this to her through this nonverbal communication that you have talked to us about, right?
I think I probably apologized to her before 2 hours.
I understand that, but my point is you didn't have to apologize immediately upon walking in, right?
No.
You could have waited 1 or 2 hours to see how she dealt with you, to see whether or not she was going to trust you, right?
I guess I'm not sure why this is such an issue.
Judge, she's being non-responsive.
Sustained?
Ma'am, you understand that you're here to answer my questions, right?
Yes.
So my question to you is, in terms of this apology, it's true that it wasn't necessary within the first 5 minutes or the first half hour because you spent actually 8 hours with her, right?
I felt that it was necessary. That's why I did it.
I understand that you felt that it was necessary, but you weren't compelled to apologize, were you?
Objection, you answered several times.
And during this conversation, you talked to her about what happened, right?
Yes.
And during this conversation, one of the other things that happened is that you had a really good feeling about her, right?
I had a more positive feeling than I did prior to meeting with her, but I don't know that really good. I had a much better feeling about her after I spoke with her.
Isn't it true that you and I had a conversation back on November 14th of 2012?
Yes, it is.
Isn't it true that you indicated to me that you looked at the materials and you received a lot of information and you had a good feeling about her?
I did. I said a good feeling. I did.
And so this good feeling that you had about her, again, this is on a personal level, feelings, isn't it?
It was, yes, she answered questions that I had. She filled in blanks that I had.
Right, and so as a result of that, you developed, if you will, something inside your brain, which is the thing that creates the testimony that we have here. In there was a good feeling. You've apologized because you felt bad. Now you have a good feeling after talking to her, right?
A good feeling. I have a better feeling to pursue the case, for sure.
I'm not asking about a better feeling to pursue the case. I'm asking about a good feeling about her because that's what you told me, that you developed a good feeling about her. Do you remember telling me that?
Yes, I do. Yes, I do.
And so now not only have you apologized, now in your mind, which is what you've told us, how you arrive at your opinions in this case, something that we can't look at, correct? We can't go inside your brain, open it up, and look at the way things develop, can we?
No, but you mischaracterized what I said.
I understand that you believe that. So now you have this good feeling, and then you continue on with the case, right?
Yes, I did.
Isn't it clear to you, as you sit here today, that perhaps there's an issue of bias on your part, on behalf of the defendant, given your feelings and what you've done?
No, I don't believe that there is.
So you can set all these good feelings aside then, right?
I have good.
Mischaracterizing what was happening in the interview with regard to good feelings.
Overruled.
Right?
I think that what you're talking about is that I have positive feelings and that would really interfere with my look at some objective material. And I'm not saying that I'm not a human being and I'm not affected by good feelings. I'm saying that I look at lots of things because I take this case very seriously. It's a very serious case.
But in this case, there are no objective materials, are there? Like a test, are there?
I don't think tests are objective.
So you're saying, for example, if we have a DNA test, that's not objective?
I'm not talking about DNA. I'm talking about, I thought you were talking about psychological
No, we're
testing.
talking about things like that.
No, I'm not saying that. I'm saying that I look at materials that are written from a variety of sources, including Mr. Alexander, and I took all of that into account. I didn't just take Miss Arias's words into account.
One of the things that you told us, or you told me during the interview, and you told us during testimony, was that the defendant suffered from low self-esteem. Do you remember telling us that?
Yes.
Well, now, one of the things that, with regard to low self-esteem, isn't it true that when the defendant was about to be evaluated, isn't it true that she was happy because she believed that her IQ was as high as Einstein's? Do you know anything about that?
Yes, I do.
And in fact, that speaks against somebody who has low self-esteem, right?
Not necessarily.
So the fact that the defendant was happy to have her IQ tested because she believes she's on the level with Einstein doesn't indicate to you that this individual does not suffer from a low self-esteem issue.
Most people who talk about how smart they are don't feel that they're that smart, or they're really interested as, by the way, I did do testing as an undergraduate. When I did my practice test, people were very interested in their IQ because it's interesting. So there could be a number of reasons why she was excited about that. I don't know, I wasn't there.
Well, but the bottom line is you had it in your notes, right? You read that, correct?
Yes, I did.
And you're saying that, well, all these other people have these reasons why they want to know what their IQ is. You don't know that's why the defendant wanted to know about her IQ, right?
No, I don't.
Because you didn't ask her, right?
No, I didn't.
And it could be that she has a very high self-esteem and she believes it, and this is going to be confirmation for her. Overall, that she is smarter than almost anyone else.
I don't believe her behavior demonstrates high self-esteem, Mr. Martinez.
You're talking about behavior, we're talking about an IQ test. And her indication that she believes that her IQ may be as high as Einstein's.
Self-esteem is not just about IQ, Mr. Martinez.
Right? It could be about other things. For example, one of the things that we know about her is that whenever she had an issue with people, she would correct everybody's grammar, right?
There were people who said that, yes.
Well, this is part of what you read going into this interview with her, right? The first interview, right?
Yes.
And so you now know this information. You're walking into this interview knowing that she's corrected other people with regard to their grammar, right?
Actually, I don't know that I had read that yet. I'm not sure. I was given a limited amount of information prior to going in to see Ms. Arias, and I can't exactly tell you which things I was given a year and a half ago prior to meeting with her.
But at least you now know that that's something that is out there and you have in your notes, correct?
Yes.
So now we have a situation where she believes she's intelligent, she corrects other people's grammar. Isn't that an indication to you, ma'am, about somebody who has a high sense of self?
Not at all.
All right. The other thing, ma'am, is that, do you remember when she was in jail up in Wairika and the defendant's manifesto? Do you know anything about that?
I don't know anything about
Do you
that.
remember that that was in your notes?
I remember hearing about it. I've never seen it.
You haven't seen the manifesto. I'm not asking if you've seen the manifesto, but you've heard about it, right? Right?
I've only heard that there was a manifesto. I don't honestly know anything about it.
And I understand you may not have seen it, but isn't it true that the defendant was signing or autographing copies of the manifesto?
Objection. May we approach? Okay.
May continue.
Ma'am, with regard to this manifesto, I understand you haven't seen it, but in your notes, doesn't it indicate that the defendant actually sign copies of the manifesto to distribute in case she became famous.
I believe those were in my notes.
And again, if that is true, doesn't that speak against the idea that the defendant lacks self-esteem?
No, I don't think it does at all. I think you can also have self-esteem issues in particular areas of your life. But I don't think because somebody writes something and thinks it's great, she may think she's a good writer, and that may be part of feeling good about herself, because most of us have areas that we feel good about ourselves, but it doesn't mean we have high self-esteem in the rest of our lives.
You're also familiar with the results of the MCI, correct? The test.
I took notes on it, but as you've already mentioned, I'm not an expert in testing.
Right, but you did note in it when you were talking about self-esteem, right? You took note of what the results were on self-esteem.
Yes.
And you actually thought it was important enough to write them in your notes, right?
I took notes on everything that was in the test. But as you said, I'm not an expert on testing, so being able to interpret that is another thing. But I did take notes on it, sure.
I'm not asking you to interpret it. I'm asking whether or not your notes reflect that the defendant has no self-esteem problems.
That was at that time, which was years after she left the relationship. One of the things about the testing, if you want to bring up testing, it was done after Miss Arias was in jail for a significant period of time.
I understand, but there's a test that says she has no self-esteem problems, right?
Objection, beyond the scope of this experts.
Overruled.
Right? There's a test that says that, right?
If I wrote that in my notes, then that's what I wrote in my
Do
notes.
you want to look at your notes?
Sure.
Okay.
Yeah.
May I take a look at Exhibit 602? Sure. Read all of it if you want, and then let me know when you're done reading it. Sure. Are you done?
Yes, you're looking at social, I'm sorry.
If I may have that, please.
Sure.
This is a page which is a copy of your notes, correct?
Yes,
And this is in your handwriting, correct?
yes.
And one of the things that it talks about is the MCMI, correct?
Correct.
You looked at it, right?
I looked at the reports.
Sure.
Yeah,
And it was important enough for you to look at that report so that you could include it as part of your assessment, right?
correct.
And in it, you looked at the social functioning scales, right?
Right.
And you found in your own handwriting that they were within the,
That's a testimony with regard to what's in her notes about something that's not in evidence.
Overruled.
that it was in the normal range, right?
Her social functioning, that's not the same as self-esteem.
Well, it does talk about self-image, doesn't it?
It says it's within the normal range.
Right. And we're in it, her self-image is within the normal range, correct?
Correct.
And you're saying now that somebody's self-image doesn't have anything to do with self-esteem?
Judge, objection. May we approach?
Yes. We continue.
You've now told us that this was, self-image was within the normal range, correct?
Correct.
So we now have an individual who has a test that says her self-image is within the normal range, correct?
Given 2 years after the incident.
I understand that, but that's what it says, right?
Within the normal range at the time it was given. Correct.
You've said that before, we assume that. We
Yes.
also have an individual who's very happy about being tested because she believes that she's as smart as Einstein, right?
Objection is characterized in the previous testimony.
Sustained.
That her IQ is as high as Einstein's.
Same objection.
Yes, she says that.
And she's signing manifestos because she believes she's going to be famous.
I don't know if she believes she's going to be famous, but she's signing manifestos.
Do you want to look at your notes where you indicate that?
If I said that in my notes, then it's,
No, I'm asking you if you want to look at your notes so that you can make sure that you're accurate. You want to look at
yes,
them?
yes.
All right. Take a look at exhibit 603 and read it to yourself.
Yes. I'm going to ask that you go out to the jury room for approximately 3 minutes. Only 3 minutes, so don't go far. We'll bring you right back. Please remember the admonition. Who's back for the jury? Record will show the jury has left the courtroom. We are in recess for 3 minutes. 3 minutes. All right, let's bring the jury in. Ms. Laviolette, please take the stand. Please stand for the jury. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. You may continue.
Have you had a chance to review Exhibit 603?
Yes, I have, Mr. Martinez.
And with regard to this 603, it's an important page, isn't it?
It's, you mean the statement about the manifesto or the whole
just
page?
the page.
I read the highlighted section. Did you want me to read the entire
Go ahead.
page?
Go ahead and look at 603 again.
Okay. I just was reading the highlighted.
And ma'am, with regard to this document, it does say important page, doesn't it?
Yes, it does.
And a page is 8.5 by 11, correct?
Correct.
And in this is the issue involving the manifesto, right?
Correct.
It's at the top upper left-hand corner, correct?
It's what?
It's written about on the upper left-hand corner at the top, right?
Right. What?
Sustained rephrase.
Well, with regard to this page, there is an upper left-hand corner at the very top, right?
Yes.
And on the margins, on the upper left-hand corner, don't you reference the manifesto?
I didn't look at the upper left-hand corner. I looked at the body of what was written.
Sure. Just take a quick look. See that at the upper left-hand corner?
Yes. Yeah.
You do reference the manifesto, correct?
Yes, I do.
And then this issue of the manifesto and the signing and all that is in the middle portion, correct?
Correct.
So this is something that you consider important.
I did.
And with regard to that, isn't it true that the defendant asked somebody named Amy to print out 2 copies of the last page of the manifesto and had them signed,
Overruled.
had them signed in case
Approach, please.
You may continue.
Isn't it true that the defendant signed those, according to your notes, in case she became famous?
Objection, just discussed.
Overruled.
You may answer.
That information I received from
Ma'am, it's
Amy.
yes or no. It really is. It's a yes or no question.
I didn't get the information from Ms. Arias.
Judge, she's just not.
I got the information from Amy, and she said that, yes.
So are you saying Amy is lying?
No, I'm not. I'm saying I didn't get it from Ms. Arias, that's all.
I'm not asking you where you got it, did I?
Okay,
All I'm asking you is for the substance of it, right?
right.
And you had no reason to believe that Amy was not telling the truth,
Overruled.
right?
Right.
In terms of, Judge, do you want to do the other thing that we talked about?
Ladies and gentlemen, we're going to take the evening recess at this time. Please be back in the designated area at 9:30 tomorrow morning. Please remember the admonition. You are excused.